Hear ye. This court is now in session. The Honorable Chief Justice Reese S. Hodge, the Honorable Associate Justice Maria M. Cabret, and Honorable Associate Justice Ive Arlington Swan presiding. Please be seated.
Good morning, everyone. We will commence with the first case, Julian versus Matthew. Sorry. Well, the first case is Great Bay Condominium Owners Association, Inc. versus Neighborhood Association, Inc. Number 2 of 2022. Attorney Hodge, who's the appellant?
I am the appellant, Your Honor.
You probably should.
I should be on that side.
Yeah, that's. Okay, counsel, you may approach and
Chief Justice Hodge, and may it please the court, my name is David Wenzel, and I'm appearing for the appellant Great Bay Condominium Owners Association. I would like to reserve 5 minutes of my time for rebuttal.
very well. May proceed.
These are consolidated appeals from interlocutory orders of the Superior Court granting preliminary injunction in favor of the appellee, the Neighborhood Association. At the heart of both appeals is the foundational question of whether the appellee's request for injunctive relief was properly before the Superior Court. And we would submit to Your Honors that this question is controlled and answered in the negative according to this court's controlling precedents, which hold that a claim for injunctive relief cannot be raised by a motion. Rather, it must be contained in the party's pleading, and that in the absence of a claim in the party's pleading, the court lacks authority to adjudicate a request for such injunctive relief raised for the first time in a motion. There are several of this court's precedents that directly address this question, and they include Caribbean Healthways versus James, 55 VI 691, Bryan v. Fox, 61 VI 416, and Marsh Monsanto versus Clarenbach, 66 VI 366. In each of these cases, this court held that it was error for the Superior Court to provide injunctive relief when no claim for such relief had been pleaded in the party's complaint or counterclaim in the case of Clarenbach. This court's decision in Caribbean Healthways is particularly salient. In that case, the plaintiff's complaint did allege claims for declaratory judgment and an injunction seeking to recognize an express easement in the documents that were at issue in that case. But the plaintiffs later filed motion for summary judgment and permanent injunction asserted an implied easement, not the express easement that was alleged in the complaint. The Superior Court granted the defendant's motion for injunction, which was pled in its counterclaim, and denied the plaintiff's motion. And in affirming the Superior Court's ruling, this court held that because the claim for implied easement was not contained in Healthway's pleading, only a claim for an express easement was pled, the issue of the implied easement was not properly before the Superior Court. And this court said that since there was no claim to recognize an implied easement, the party was required to seek leave to amend its complaint before that claim could properly be decided by the Superior Court.
But in this claim, wasn't it the main claim of the complaint that the conveyance of the unit, the commercial unit back to the association was improper, and when the defendant denied that, wasn't that really brought into play before the court?
No, Your Honor. The complaint in this case below that is being appealed from, there are two related cases in the Superior Court. This case involves ownership, title to the commercial unit at the Ritz-Carlton Club.
And that's my question. Wasn't that really the gist of this entire action?
I'm sorry, Your Honor, I didn't quite hear.
Well, the fact that the ownership was the contested issue.
Title to the unit is the contested
Correct.
issue in this case.
So why wouldn't that be well before the court?
Because
it wasn't as if there was nothing pled, and at the last minute, someone was trying to get a claim on something else.
Well, Your Honor, the injunctive relief that was granted did not pertain to issues related to the title or ownership of CU1.
How not? How not? I mean, Great Bay Association filed a case, and Great Bay wants declaratory judgment that a deed that the neighborhood association purported to convey to Great Bay. Great Bay wants that deed annulled, canceled, whatever you want to call it, but they want to declare that conveyance invalid, and they want the court to declare that neighborhood association remains the owner.
Correct.
How do you not see, I mean, I'm trying to figure out why you don't see that the injunction is related to the ownership and clearly related to the complaint in this case?
Your Honor, the answer is because the injunction was enjoining assessments, dues, that were assessed against the members of the neighborhood association. And responsibility for payment of dues.
But, Counselor, it's a very fundamental thing. And the other two justices have said it. This whole case, the essence of it goes toward who owns CU1 right now. In light of the deed that attorney had executed, that in essence went from neighborhood association over to Great Bay. And Great Bay is saying, no, we don't want it. But Great Bay is doing some assessment. And neighborhood association is saying, well, we don't own it anymore, so we don't owe anything, no assessment or otherwise. And I'm talking because there are two assessments to the neighborhood association people.
Yes, Justice.
those owners, the neighborhood association assessment and grade bay assessment. And what they're really saying is that we do not own anything anymore in CU1 because we have deeded. We are authorized, the Board of Neighborhood Association authorized us to deed it to Great Bay. And the whole issue is whether or not anywhere in the declaration of both can neighborhood association willy-nilly or at any time, and this is what Attorney Hatch has to say, at any time that neighborhood association feel as if that is convenient for them to turn it over, then they did turn it over. CU1 unit, the lounge unit, the money unit, I like to call it, because there's a lounge up there. And they even said that even after we turn it over to you, apparently the owners that come under the neighborhood association, they couldn't even hold a meeting at the CU1 unit because Great Bay have commandeered the whole thing. Yes, still, and I get the impression, this impression I get from reading all of these volumes, that Great Bay is saying, we rejected the deed, we no longer own it, but there is some assessment that's due. But simultaneously, you have the action of ownership of CU is utilizing it. And what neighborhood association say, that's what you have been doing, holding functions there, chefs there, cooking there, and everything else, but we can't use it. So we shouldn't have to pay for it.
But, Your Honor, the question of who owes the assessments for the expenses related to operation and ownership of CU1 is separate.
Was the deed recorded up in the Record of Deeds office?
The deed was recorded after payment of taxes that occurred in March.
Right, okay.
So as of today's date,
Who owns it?
Great Bay is the record owner of CU1.
Well, in this case, we've alleged that conditions precedent in the declarations to the ability to transfer it were not satisfied. So we do not concede or agree that we currently own the unit. But we do say that the question of liability for expenses of who pays for CU1's share of the common annual maintenance expenses of the Ritz-Carlton Club is separate from the ownership of the unit. The obligation to pay the expenses, the unit is a resident, and like
Let me ask you this. Are you saying that the assessment letters that went out to all of the owners of the neighborhood association has absolutely nothing to do with CU1, but it has to do with the overall assessment of everybody that is connected to Great Bay?
No, Your Honor. The neighborhood association members received two assessments.
Right, one from Great Bay and one from the neighborhood.
That's correct. And the one from the neighborhood association is for the costs and expenses of owning and operating CU1. Right. CU1 owes a share of the common expenses, right. And the declarations provide that the obligation to pay CU1's share of the expenses of the club at large is pertinent to the ownership interest held by the members of the neighborhood association. Well, it is not pertinent to ownership of the unit.
That is the same reason why the deeded neighborhood association deeded it to Great Bay, so that they do not have to pay anything for CU1. Because of their contending is that we can't use it for meetings, we can't use it for any purpose. And then they even went and said, which you have disputed, they said, well, if we don't pay up, we're going to be locked out, not only out of CU1, but the whole entire complex.
That is the position of the neighborhood association, right? But our position and our contention is that the obligation to pay CU1's share is clearly and unambiguously spelled out in the declarations as pertinent to the ownership interests of the members of NA, Neighborhood Association, who own residence interests in those two particular buildings that serve CU1. CU1's use is
Didn't they
restricted.
expand it to all of the members and had some adjustments in the contributions?
It can only be done, Your Honor, and it was being negotiated.
Wasn't that done? Wasn't there two amendments that allow all of the members to use it and they would contribute somehow?
No, Your Honor, there were no amendments to the declarations that.
Well, I'm not saying the declarations, but wasn't there agreements that instead of just the two-bedroom units using it, that all of the units will have access to it and they were actually contributing to the payments?
There was a contractual agreement.
Exactly.
that expired. It was a one-year agreement. It was renewed a second time, and it was renewed a third time, and then those three contracts expired.
Now, with respect to the court's finding on both of those issues, the ownership and the right to pay, you says that they had to pay regardless to who owns it. And the court made a determination. Where is that clearly erroneous that we can reverse on that?
Because there is no claim by the neighborhood association in a pleading that sets forth the basis of its claim, that merely transferring ownership
Well, let's
also.
just accept that the ownership issue is a disputed issue in this case, and the court made a ruling, it made a ruling basically from ambiguous contracts, basically, because you're arguing one thing, the other side is arguing the other, the court made a determination. Where is the court clearly erroneous on our review of that determination?
By deciding the separate question of liability of the personal liability of the members of the neighborhood association to pay expenses of CU1 regardless of who owns
But
it.
it analyzed the contract and it made a determination. It says it would be ridiculous to have people who don't own it to continue to pay. And it interpreted the terms of that contract or the declaration and made a determination. Is that clearly erroneous on our review?
Well, we don't think that the ownership of the unit is what determines obligation to pay for it. There are two separate things, and those are.
And we understand that.
Yes.
What we are trying to find out is where did the court make any kind of error, whether it was an application of law to fact, whether it was making a finding that was clearly erroneous. I mean, what did the court do that was wrong, other than your argument that the neighborhood association had to plead, make an affirmative claim for relief in order to get a preliminary injunction, because this is a preliminary and not a permanent injunction.
That is the principal basis of error, is the adjudication of a claim for injunctive relief first raised in a motion, which this court's precedents hold is not permissible.
Well,
but the other error.
The Caribbean Heathways case that you are hanging your hat on so very strongly. In that case, there was the grant of an injunction for an implied easement, and that had not been pled. And please, we also look at the stage that this case was, that Caribbean Heathways was. It was at the summary judgment stage. That was the end of it. That was going to be, that was going to be the end of the case. Here, we are at the preliminary stage. Discovery is ongoing.
Your Honor, this court ruled in Caribbean Healthways that the permanent injunction was interlocutory. And so it was at the interlocutory stage when this court ruled. And in fact, this court said that on remand, it may seek to amend its complaint to allege this claim for an implied easement. So they were in a similar posture. The other reason it's error for the court to have adjudicated this unpleaded claim is because it essentially adjudicated in rem remedies. It adjudicated the rights and liabilities of every owner of any unit at the Great Bay Condominium. And those parties are not before the Superior Court in that case. So by adjudicating that the obligation to pay for CU1 follows the unit, that determines the property rights of all the members of NA. It extinguishes the restrictive covenant in the declarations that places that obligation on them, and it puts that obligation on all the other members and owners of Great Bay Condominium. And none of those parties are before the court. This raises the question of associational standing.
You've gone to another issue.
Yeah, and I think you've gone over 7 minutes, so you can reserve that on your rebuttal. So thank you for your.
Thank you.
Good morning. May it please the court. Maria Tankinson Hodge for the appellee, the Neighborhood Association, Inc. I'd like to begin, if I may, this morning by just pointing out that at least the last part of the appellant's argument was squarely within the areas that this court has already indicated are not before you on this appeal. As you will recall, this is a case in which the appellant sought to file a second principal brief with a host of new issues that are not in their appeal before you today. And upon our objection, the court agreed that was not proper and ordered that brief stricken. And these issues that the appellant's counsel was last trying to raise are those exact same issues that have already been held stricken from this appeal. So I would ask the court not to dwell on that. I don't think that's what's before you. The appellant's brief in this case raised two issues, literally exactly two issues in the brief on appeal. First, whether the Superior Court erred in granting the appellee's motion for a TRO and preliminary injunction in the absence of any counterclaim for injunctive relief or other affirmative relief in appellee's pleadings. And second, whether the Superior Court abused its discretion in granting a preliminary injunction to appellant without stating findings and conclusions of law. That second point is clearly incorrect. The court's extensive written opinion is in your appendix. I don't know why they put it in their brief. It's as if they wrote their brief before they put together the appendix and recognized that they already had an extensive and thorough adjudication of the issues in the court's final opinion. The court had also signed a TRO with findings and made findings at an oral hearing. So the second issue really should not detain the court. The first issue I would submit to the court is just plainly wrong. There is no holding in any of the cases cited to this court that a defendant cannot have a request to protect the status quo granted in a TRO or preliminary injunction unless it has filed a counterclaim. And it's counterintuitive to have such a rule because the whole concept of a preliminary injunction is to preserve the status quo while the court examines the parties' allegations. In this case, it is correct that Neighborhood Association didn't file a counterclaim, but its answer was full of specific affirmative contentions that support its position here. In its answer, it denied the material allegations of Great Bay that it wasn't entitled to issue this deed to them for this unit. It alleged that none of the deficiencies complained of had any merit. It specifically affirmatively alleged that the purported rejection of the deed by Great Bay was null and void. All of this is in the appendix in the answer at page 461. By the way, I inadvertently said in my brief that the answer had been omitted from the appendix, and that's because it somehow didn't show up in the table of contents. But the answer is in the appendix. And it clearly indicates that Neighborhood Association repeatedly and affirmatively indicated its position about this, which was that Great Bay had become the owner of this unit from the time the deed was delivered, that the Fourth Amendment to the Declaration permitted them to give that deed to Great Bay without any requirement that Great Bay consent, that they had done so, that they had recorded the deed. None of that is disputed. And
What would have happened if they moved to dismiss their complaint and move the court and the court granted?
I'm sorry, Your Honor, what would have
What would
happened?
have happened if they made a motion just to dismiss their complaint and the court granted that? What would happen to your claim?
We would have probably
You
had to
didn't
file
have a
our own,
claim.
but we would have probably had to file our own case seeking injunctive relief. But we had a matter already before the court in which this fundamental question about whether the owner of a condominium under Virgin Islands law is the one that's responsible for common charges, or whether somehow a party like Great Bay can claim that some prior owner is going to be responsible for common charges in perpetuity. And Judge Cardi below said in her opinion, and I think so clearly correctly, that not only the declaration provides that the owner of a condominium is responsible for the common charges, but the Virgin Islands Code, Title 28 Virgin Islands Code Section 909 provides that the owner of a condominium is the one who's responsible for the common charges. A party can't change that by writing a declaration that says we don't like that. We're going to make the people who used to own the condominium last year responsible for common charges in perpetuity. And
So what in the agreement give you the right to reconvey it? I understand that it says that they can convey it to an association, but is there anything that allows it to reconvey it?
that would allow them to reconvey to us.
You to reconvey it back to them?
I'm losing the us and them, Justice Hodge. The declaration specific.
It was conveyed to neighborhood.
Correct.
And then neighborhood, on the day that the hurricane occurred, convey it back.
Correct.
And where in the declarations does it says that it provided for one conveyance, that it would provide that it can be reconveyed back?
Right. So it's in the declaration, Your Honor, that
I
they
know what it
made
says. It says that the owner can convey it to an association.
without any need for them to accept.
And in this case, the owner did convey it to the association, neighborhood. I'm wondering, how can it be conveyed back?
You mean, could Great Bay convey it back to neighborhood
Oh, no,
association?
the neighborhood convey it back once they got it.
So what I'm saying, Your Honor, is that the declaration specifically says that the owner of a commercial unit may convey it without the consent of any owner to the association, and the association shall be obligated to accept such conveyance. That
What I'm
direction,
saying is that occurred, right?
that did occur.
Great Bay conveyed it to neighborhood.
No, I'm sorry, that's the reverse, Your Honor. The
But
neighborhood association,
initially, how did neighborhood get it? Wasn't it?
the sponsor originally,
Yeah, Ritz-Carlton.
that wouldn't have been Great Bay.
Right.
That would, the original title did not come to neighborhood
That's right. Let's
association
say
from
it
Great
came
Bay.
from Ritz-Carlton or whoever was the
Correct.
sponsor.
Right,
It says the sponsor or the owner could convey it to the
Correct.
association. Here, the
Okay,
sponsor conveyed it to the association.
neighborhood association.
Right. So now how can the association now convey it to another association?
The neighborhood association is the owner of the commercial unit, and under the express language of the declaration, the same declaration that actually created the neighborhood association says that the owner of a commercial unit, and I'm quoting now, without the consent of any other owner or the association being Great Bay, may convey title to the unit to the association, and, quote, the association shall be obligated to accept such conveyance, close quote. That's in the declaration that's in the appendix at page 81, and it's cited in the opinion of the court below at appendix page 1570. It's a one-way,
So then, under your reading, Great Bay now as the owner
Correct.
could reconvey it back?
not at all.
Why not?
Because the conveyance that is authorized is a conveyance to Great Bay, the association, the overall condominium association for the property. It wasn't an entitlement in there to convey to anyone at any time, only a right of a commercial unit owner to convey to the Great Bay Condominium Association. It was a method that would allow the
So
commercial.
neighborhood is not an association?
It is an association, but in this declaration, it is not, quote, the association with a capital A. It is, it's a corporation. The Neighborhood Association, Inc. is a corporation. It was the owner of CU1, and it exercised its granted authority under the declaration to convey title to the unit to Great Bay, the association in this declaration. And I would submit as
So
well,
you're saying that in this case, we shouldn't consider the obligation to pay, regardless to who owns it, because that wasn't raised in this brief?
right, I do not think that that is before you. I think the only issue before you is, did the court below err in granting any preliminary injunctive relief in the absence of a formal counterclaim, even if this issue was squarely before the court in the pleadings?
Let's assume that it is before us.
If it is before you,
Would it stop being based on who owns it? Would the contributions stop?
so my position, Justice Hodge, is that under the Virgin Islands Code, the section I cited, that's 28 VIC 909, the owner of a condominium is responsible for the common charges, that's a legal obligation that automatically follows title.
As a matter of fact, that was the primary reason why Neighborhood Association deeded CU1 to Great Bay. And in essence saying, you know, all these assessments against us is just wrong because you are assessing for things that concern CU1 and we no longer the owner of CU1. And then when Great Bay get upset and annoyed and flabbergasted, even though they were using CU1 for their own type of activities, they said, you know what? We got to do something about this. What was it, over $1 million now?
$1 million.
Over $1 million. I'm not concerned, over $1 million without the interest or without anything. So basically, and then according to you, Attorney Hodge, in your letters to them, you were saying that they have received information from Great Bay that said that unless you come up with the money for this assessment within X number of days, you would be locked out of everything,
Correct.
even what you are entitled to as a part of Great Bay.
Correct.
The entire facility, you would be out of it. You wouldn't be able to use it. Your use of your units gone, but you still have this debt owed to Great Bay, and that's what we are seeking. So that's the essence of basically what this is all about. The deeding of the CU1 unit and everything else is just collateral to that. But the whole essence of this thing is that Great Bay is saying, we have an assessment against you people over there in Neighborhood Association, Inc. We have assessed your unit. It's over $1 million and growing over the last 4 years. And now we're going to have to do something about that, and which entails is that according to our bylaws or our declaration, we can prevent you from not only using CU1, but all the other parts of the Ritz-Carlton issues.
Including their own residences.
Including their own residence. And in the meantime, they're using CU1. And that's basically one of the essence of the whole gripe is that the superciliousness of assessing me for a unit that you own according to the deed and you are utilizing, and we can't even hold it for our annual, we can't even utilize it for our annual meeting. We can't even go there. They might be locked out from even going there to have a meal, because that's what CU1, the lunch was all about. Well, it wasn't that alone, but one of the main things about CU1 is having that lounge at the top floor that serves as a restaurant for the owners of CU, or not the owners, but those are people of CU1. And if you take that away from them, then what else is there? Plus, you're seeking to charge them for all this amount of money. That's basically what this gripe is all about.
Correct.
Was the neighborhood paying those dues for 2 years before it was actually conveyed to them?
They were paying the common charges, to my understanding, Your Honor, as long as they were the owner.
Well, even before it was officially
Conveyed.
conveyed to them, hadn't they started paying?
There is an indication that there was some gap between the formal transfer of title and the commencement of payment, apparently due to just, oversight
But
on Justice Hodge.
Would that indicate that the obligation to pay the dues didn't really necessarily follow the title?
No, I don't think so. I think all that indicates is that an early stage in the creation of this entity, people hadn't fully thought through that, or perhaps just that the sponsor was delayed in getting the deed recorded. Because at the beginning, there's no doubt that neighborhood association's purpose for existence was going to be to own and operate that lounge. But after a period of years, that no longer became viable, and there was an agreement, as you'll see in the record, with Great Bay in which it was going to be voluntarily transferred to Great Bay. But when that collapsed, and the decision was made that they had to go ahead and transfer it anyway, because they couldn't allow themselves to stay as they were, the deed was executed and delivered. And I would say, just in conclusion, if I may, even if an argument is made that there's some debate about whether the obligation to pay common charges automatically follows ownership, and we submit that the Superior Court judge was correct in holding that it does. It certainly wouldn't be true that it was clearly erroneous for her to make the determination that in this context, that she should protect the status quo and protect the neighborhood association members from this massive assessment, while she determines with finality the question of who the actual owner is and who the responsible party is. They shouldn't be permitted in the midst of the case before the trial judge to use this self-help mechanism to collect this money. I had a little analogy for you, if I could just have 1 second to give it to you, and that is if you had a case in which a neighbor claimed an easement over your property to get to their place, and you were in court waiting for the court to determine if their easement was valid or not, and they suddenly started cutting down trees on your land and paving your land.
Several cases that have held exactly that. There are cases that in landlord-tenant, while it's pending, there's been no counterclaim, and the landlord used self-help, the court can, of course, enter
That's my position.
And in fact, I think it's section 243 of
We had a lot of those
clearly
cases
allow
of
the
Maryland
court
down there.
an exercise of its to protect its jurisdiction to enter such a judgment. But anyway,
Thank you for
That's
your
for another
thank
day.
you for your
Thank you.
attention.
counsel.
Thank you, Your Honors. The issue of the injunction affecting parties who are not before the court is raised in appellant's brief at page 20, not the brief that was stricken, the initial brief. And it's in the context of the discussion that because there is no pleading asserting and identifying who this claim for request for injunctive relief is brought on behalf of, we don't know who it is being brought on behalf of. The largest owners of the interests in the neighborhood association are two corporations, the Marriott Vacation Trust and the developer. Those entities, which comprise
49%.
almost 50%.
49%, not 50.
That's right. They agree with our position.
Of course, because they're you.
Is that relevant though? But I do want to go to I mean, the fact that some members of the association may have paid, is that relevant?
Yes, because the lack of a pleading, Rule 8 requires the pleading to be set forth, and Rule 10 requires the parties to be identified. And so here, we pointed out that 49% of the owners admit the liability regardless of who owns the unit. So that the issue, the one who drafted the declarations agrees that the obligation to pay CU1 expenses is separate from who owns the unit. And Your Honor is correct that the assessments were paid by the owners of NA. During the 3 years, the developer still owned the unit. And that's further indication that the issue of obligation to pay is a restrictive covenant that is separate. It's a pertinent not to CU1. It doesn't follow CU1. It follows the ownership interest of the unit owners in those two buildings. And that is why the lack of a pleading made it deprived us of any opportunity to raise issues of whether they're standing to assert claims on behalf of entities
Let me
that,
ask you
that
this.
admit the
If-
liability.
If that's the case, why did Great Bay file its motion to declare the deed, which neighborhood association signed to it, invalid? I mean, if it doesn't matter who owns the unit, would it not be to Great Bay's interest to say, Judge, make them pay? We may not own the unit, but these interests run with the ownership of the suite. So guess what? We get to control the unit, we get to use it, but they have to pay.
But because it's a huge managerial responsibility that would be being foisted on the association, which is run by a handful of volunteers.
Were there not negotiations to do just what neighborhood association did, to transfer ownership of CU1 to Great Bay?
Yes, Your Honor. There were negotiations. They did not come to fruition, and no agreement was reached. And when no agreement was reached, that's when NA unilaterally conveyed it. And Justice Swan, if I might address something that you've been pointing out, the CU1 is completely inactive since the hurricanes. It does not function as a restaurant. People aren't going there for dinner. There was reference in the
Right,
hearing
I read it in the record.
that there were a couple of functions that where speaker was invited, but that unit is totally non-functional and disoperational, and it has been since the hurricanes.
Since which hurricane? The one in 2017?
Yes, the two hurricanes in
All right, okay.
2017.
But I do know that in the record, the side, the neighborhood association is saying that not only have you locked us out from what we own or what we used to own, which is CU1, but now we have deeded to Great Bay. Great Bay is utilizing it, and when we approached them about even nominal use of it, we were rejected. But in the meantime, we have this assessment for about 5 years.
And that's, yes, Your Honor, and that's pursuant to the declarations that allow the association to deprive the use of property when the dues are not paid.
Right, but you see, but everything boils down to one factor here. Who owns CU1 and when did ownership change? There's a deed from the neighborhood association to Great Bay, and Great Bay is saying, no. We are not going to, you can record it up, record of these office, you could do what you want, but we don't care what is in the in your declaration, neighborhood association, but we don't want CU1 at all. That's one issue. But the issue is that the people from neighborhood association that have the units in the CU1 structure or building or edifice, they are complaining. They say that we continue to get these bills and they're getting ready, or we are threatened with lockout not only of CU1 but the entire Ritz-Carlton complex, the entire everything. And that's not fair to us. We might be only 208 owners or whatnot, but we are being treated differently. And so the essence of it is that who owns CU1 right now as we speak?
I agree.
Who owns it?
The neighborhood association.
Neighborhood association. Why you said the neighborhood association owns it when there's a deed on the record that you own it?
Because the declarations require that any conveyance, even if this association word means from the neighborhood association.
Okay, but what about the language that attorney has quoted, not only just now as she was speaking, but either in her brief or in her correspondence or in her motion,
Yes.
because I read it in the record, exactly what she was talking about there. And she's saying, in essence, you can't do that.
I would like
Because
to.
the declaration said, and I remember some of the language, it says that no member, no owner, nobody can object to us doing this or have a say in terms of our neighborhood association deeding to Great Bay CU1 unit. so therefore we can go ahead and do it. Whether it was oversight, I must admit, that's a draconian measure to have. And, but as I understand what the chief had asked, so suppose Great Bay now deeded back to neighborhood association. Well, I don't know what's in Great Bay declaration, but I know that in neighborhood association, Attorney Hodge is saying, and she quoted language that said that we can do this, and Great Bay can't object to it.
Justice
So
Hodge.
if in fact that if it's true that in the declaration that can be done, then it doesn't make any sense that the next day Great Bay got deeded back to them. That's all I'm saying.
I apologize, Justice Swan, and apologize to you, Justice Hodge. Justice Swan, the declaration that they quoted
Right.
is not the declaration that created CU1. This is the Fourth Amendment is the language they rely on. Right. That was the amendment that created, that submitted Building H.
So you're saying it's not part of the declaration?
What declaration, the Fourth Amendment did?
Once the declaration is amended, it's part of the declaration.
It was amended twice after this.
Yeah.
Well,
This
I
one
think it
was-
went up to 7, am I correct?
Right,
Seven
the Fourth
seven.
Amendment, which sent Building H, set up some general principles for commercial units. And the language that they're quoting, that an owner, the developer or an owner of a commercial unit, can convey it to the association without their consent. That's a general rule of commercial units being set up in anticipation of the creation of one. Paragraph 6 of the Fourth Amendment is about the specific commercial unit,
Fourth Amendment
CU1.
For the Fourth Amendment to whose declaration? The neighborhood association?
There's only one set of declarations that govern the whole condominium.
Right.
The-
So we're talking about the original declaration.
There's two sets of declarations,
Right.
the main declarations and then the club or the supplemental declarations. When the hotel sent Building H over, it was the fifth building in the club, it said, in anticipation of creating commercial units, here are some general rules. That's paragraph 5 of the Fourth Amendment, which is all they quote from. Paragraph 6 of that one, that describes the specific commercial unit, CU1. And that one says that it shall be conveyed to the neighborhood association, and its members shall be responsible for its payment. And then the subsequent Fifth Amendment.
Regardless of what all these fifth, sixth, seventh, it is a specific paragraph in the declaration that the court interpreted and determined that there's a great possibility that neighborhood will prevail on that issue and granted it. And my question again, at this preliminary stage, where can we actually review that and say that was clearly erroneous?
Well, the one reason, beside the fact that there's no pleading that sets forth the facts, the second is that the court's finding that the obligation to pay follows ownership of the unit
But isn't that the
is
law?
contrary to the court's own factual findings.
But isn't that the law as well?
No, Your Honor.
So when counsel says that 909 of the Condominium Act says that, the common charges are based on ownership?
CU1 is not a common element. It's not a common area.
Is
It's a commercial area.
But
And
isn't it divided up in a certain number of units? Is a percentage of the common areas is assigned to that?
CU1 owns a share of the common areas like every unit.
Yeah.
Right,
So,
and
don't say that it doesn't have any interest, but I think, we are really beating this.
Well, let me clear up something here, because my understanding after reading the record as to CU1, yes, it's for commercial purposes, but isn't there some apartments and ownership in terms of part of CU1?
no, Your Honor.
Then somewhere along the way, I get the distinct impression that unlike other parts of the condominium out at Ritz-Carlton, that CU1 had some small units in it that didn't have the kind of extensive kitchen facilities. And that's why it became important to have the lounge on the top floor, where the people that have these interests to utilize these units would go upstairs on the top floor in order to have meals.
CU1 is the top floor. That's it. All of the other units in those two buildings, G and H.
Alejandro Wenzel, this commercial unit is assigned a percentage of the common area, correct?
Yes, Your Honor.
Just like the other units are.
Yes, Your Honor.
So, we understand it. So, again, thank you, and the case was submitted.
Okay.
Thank you.